Friends, welcome to episode 3 in legal language. In this episode, we are going to briefly cover the arbitration and the writs as per the Constitution of India, or Bharat, you can say now. Now, what is arbitration? Arbitration is a process whereby the parties settle their dispute through an intervention of third party who is called the arbitrator. Arbitrator is a person other than the court of competent jurisdiction. It is thus a form of alternate dispute resolution, or also called ADR. This process is much faster and cheaper than the legal process through court. Legal technicalities do not attach to arbitration proceedings, and provisions of Indian Evidence Act also do not apply to arbitration process. The arbitrators hear the parties and give their decisions, which is called award, which is binding on both the parties. The dispute may be referred to one arbitrator or more than one, maybe usually 3 or even more than that, as the case may be. Arbitration agreement may be a separate agreement between the parties or may be in the form of an arbitration clause in their commercial agreement and contract. In India, the arbitration agreement must be in writing. Under Section 28 of the Indian Contract Act, an agreement to oust the jurisdiction of court is void. That means you cannot have a clause that no party will be able to move the court in case of disagreement. That agreement clause is void. Provisions governing arbitration are found in Arbitration and Conciliation Act 1996. However, if an award given by arbitrator is not acceptable to any party, the doors of court are always open. Criminal matters, matrimonial matters, insolvency proceedings, and lunacy proceedings cannot be referred to arbitrators. This is important to be noted. Now, let's see what are the writs. Now, the right to enforce a fundamental right is itself a fundamental right under the Indian Constitution. Thus, any person whose fundamental right as per the Constitution of India is violated can move the High Court under Section 226 or the Supreme Court under Article 32, and the court can issue orders which are called writs. The fundamental rights are right to equality, right to freedom, cultural, educational rights as enumerated in Article 14 to Article 21 of the Constitution. Chapter 3. The various types of writs are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now let's see each of these. What is habeas corpus? Is a Latin term which means produce the body. It is a writ through which a prisoner can be released from unlawful detention. This remedy is available in all cases of unlawful detention and deprivation of personal liberty. The writ is a judicial mandate to a prisoner official or prison official ordering that an inmate be produced before the court to determine whether or not he should be released from the prison. Normally, the arrested person makes the application, but a relative or a friend can also put a writ of habeas corpus. What is mandamus? Mandamus is a writ meaning we command. This is directed against any public authority or government body requiring it to do something stated therein. The object of mandamus is to compel the performance of a public duty. Writ of mandamus lies not only against executive authorities but also against judicial and quasi-judicial authorities. In a landmark judgment by Supreme Court, the Supreme Court directed the Bombay Municipal Corporation to implement a town planning scheme which was also approved by state government but was not getting implemented for long period. Now what is writ of prohibition? Writ of prohibition is issued by a superior court directing the inferior court not to exercise jurisdiction which is not legally vested in it. Thus, it compels a court to keep itself within its limits. It is issued when a court is acting without jurisdiction, exceeds its jurisdiction, acting in violation of rules of natural justice, proceeding under a law which is unconstitutional or ultra vires, and is acting against fundamental rights. So the superior court issues a writ of prohibition on the inferior court to not proceed with the case. Now what is writ of certiorari? Now writ of certiorari means to be more fully informed of. A writ issued by superior court directing an inferior court to transmit to superior court all the records of a pending matter in order to speed up the matter. This writ is to enable the superior court to exercise its authority to ensure that the subordinate court is exercising its jurisdiction properly. Last one is writ of quo warranto. This literally means asking by what warrant this. By what warrant? This is a writ issued by the court to a person when he acts in the capacity to which he is not entitled to act. If a person asserts to a public office to which he is not entitled to or not legally qualified, this writ can be issued. This writ can be prayed against even chief minister, judges of high court, chairman of municipality, etc. Court may refuse to grant this writ where there is acceptance on the part of the applicant, when officer has already stopped acting in said office, or when an effective alternate remedy is available. Thus, the writs enables a person to straight away go to High Court or Supreme Court authorized by Constitution of India whenever his fundamental rights are breached. We stop here for the day. We shall cover some more concepts in the next episode. Thank you.